Welcome back to the Lost Test channel. My name is Anton Vieltsin and I'm a criminal defense attorney here in the Southern District of California. In this video, we'll be discussing a Ninth Circuit case that deals with a situation where somebody approaches an international border patrol checkpoint, but right before driving through it, they make a U-turn or turn around right before that checkpoint to avoid it. And whether that maneuver creates enough reasonable suspicion for the Border Patrol to pull you over, or whether that seizure would be an illegal one under the Fourth Amendment. Just like I mentioned in my introduction, today we're going to be talking about United States versus Montero, a Ninth Circuit case out of El Centro, California, which is in the Southern District of California. Before we discuss the law, let's first focus on the facts. I have a map of El Centro right here on the board that will assist us with discussing the facts. El Centro is located along the United States-Mexico border. And by the way, the city is roughly 2 hours away from San Diego. It's for those people that are watching this and are not familiar with the area. Both of the cities, San Diego and El Centro, are in the Southern District of California Federal Court. Now, El Centro is located just north of the border, and we have Interstate 8 running east to west along the border. And then we have California Route 86 running north to south. Now, on Route 86, we have an international border checkpoint. For those of you that watch YouTube enough, you know there's plenty of videos discussing border checkpoints. Now, we have ports of entries. For example, there's one here where we have Calexico, Mexicali port of entry, but we also have checkpoints that are within so many miles of the border. On Route 86, we have a border checkpoint. A little bit south of it, there's a sign that tells the people who are traveling north whether that checkpoint is open or closed. The reason why they put out that sign is to tell motorists whether they need to stop for the federal officers or if they can proceed without stopping. Now, most of this area up north is open desert, especially in the year 2000. There's really nothing there. As you're looking south, the Border Patrol officers can easily see the vehicles approaching the checkpoint. But then there's area just south of this sign that is obstructed, the view is obstructed for these officers. So they cannot exactly see what happens around this turnaround. Now, this is also the area where individuals often either pick up or drop off illegal aliens, or they pick up or drop off narcotics, or at least that's what the officer testifies. Now, here's what happened. We have an individual driving north on 86. He tells the officers, gives them a tip, that he just saw two vehicles driving in tandem. And right before the sign that said that the checkpoint is open, both vehicles made a U-turn on the highway, and then both of them briefly stopped at this area, which is obstructed from the Border Patrol officers. Now, knowing that information, two officers get into their patrol cars and they start driving south. They eventually catch up to the two vehicles. The reason why it's important that these two vehicles were driving in tandem is because it's often a tactic used by people who are smuggling illegal aliens or narcotics. We have one vehicle driving up front, checking whether the Border Patrol checkpoint is open or closed, and maybe calling the vehicle behind on either to proceed or make a U-turn. And usually the vehicle up front doesn't have anything illegal inside. Now, when the officers arrive and they catch up to these two vehicles, in one vehicle there's one individual, in another vehicle there were two. One of the officers testified that when he approached the vehicle from behind, he could see in the rearview mirror that the passenger saw that the Border Patrol officer approached the vehicle, and then she put up a newspaper as though she was reading it. From that information, the officers stopped the vehicles, and inside they found marijuana, firearms, and ammunition. Now, all three defendants filed a suppression motion, arguing that the evidence found needs to be suppressed because, after all, when the officers pulled these two vehicles, they did not have reasonable suspicion to pull them over. Now, let's move on to the legal aspect and the law in this case. As you remember, the Fourth Amendment protects you against unreasonable searches and seizures. What does that mean? It means that before searching you, the officers must have a warrant. But there's the second aspect of the Fourth Amendment that I don't often discuss on this channel. But in this situation, we're dealing with seizures. Those seizures must still be reasonable. And seizures include personal belongings, but the individual himself counts as a seizure as well. The Fourth Amendment includes any seizure of a person, including even a brief detention. Before police officers, or in this case, Border Patrol officers, can stop a vehicle, they have to have reasonable suspicion supported by articulable facts that criminal activity is afoot. You might want to check out Sokolow and Terry versus Ohio. That are two Supreme Court cases that really deal and explain exactly what reasonable suspicion is when we're dealing with vehicles and people being stopped either in vehicles or really by foot. Now, when the officer stops or has reasonable suspicion to stop somebody, we're not talking about innocence or guilt. The officer doesn't have to determine whether somebody is innocent or guilty. What they have to evaluate is the degree of suspicion, whether there's enough suspicion, enough reasonable suspicion to stop somebody to investigate. And we're talking about a particular person. So the officer can't just say that the area where he's working has a lot of criminal activity, so he's gonna go ahead and stop everyone because he has reasonable suspicion that everyone in the area is committing a crime. No, we're dealing with a particular person. So these facts, the articulable facts, have to deal with that individual. Now, one thing you might be asking yourself at this point is how come the Border Patrol doesn't sort of create a reason to stop somebody? We often see cases where it seems like the officers made up a reason. The vehicle didn't make a full stop, didn't use a blinker, the tail light was out, or some other reason. But really, all of us know that the officer really wanted to investigate something else. And that's why he didn't even give the ticket for whatever that traffic violation is. Here's the reason why, in this case, the Border Patrol cannot do that. Well, in California, the state of California does not permit Border Patrol agents to enforce traffic laws. It is something for you to remember in the future. The officers can't enforce speeding when they're driving along with you on the border or along the border. So what the officers usually need to do is they have to have reasonable suspicion that you're committing some kind of federal crime, usually driving illegal aliens or driving narcotics within the country or across the border. So this is the reason why all of the reasonable suspicion has to somehow tie into federal law. In the district court, when the defendants filed the suppression motion, the court evaluated reasonable suspicion by looking at 5 particular facts that the officers testified to and wrote in their reports, the reasons why they pulled these 2 vehicles over. Now, when we're talking about the Ninth Circuit evaluates the facts under the same facts, but they say that some of these factors should have never been used in evaluating reasonable suspicion. So let's go ahead and take a look at these 5 factors. First, let's focus on the 2 factors that the Ninth Circuit says were not appropriate. The officer testified that the three defendants in this case had a Hispanic appearance. Now, we're talking about race and ethnicity here. And I'm not saying that race and ethnicity, and the court doesn't say this, that never has a reason for evaluating reasonable suspicion. But in this case, it really doesn't. 73% of the population in El Centro and Imperial County is Hispanic. So by looking at somebody and seeing that they're Hispanic, it doesn't tell the officer anything. It doesn't mean that that person is an alien. It doesn't tell them that they're an illegal alien. It doesn't tell the officer anything. And again, we're talking about individualized suspicion. And in this case, when we're saying that the three individuals looked Hispanic, well, it doesn't mean that those particular individuals must be illegal aliens. For those reasons, the court says that looking at ethnicity and race was not appropriate in this case. Moving on to the fifth factor, when one of the individuals picked up the newspaper, again, in some circumstances, that could be reasonable suspicion. But the Ninth Circuit says that in this case, it really doesn't make any sense. Eye contact kind of goes both ways. And after so many years of me working as a defense attorney, I will tell you that I've had both cases. I've had officers testify that when an individual drives by and doesn't make eye contact with law enforcement, that's indicative that they're committing some sort of crime. They're trying to avoid eye contact. But I've also had cases before in my practice that say the other way around, that some of the officers testify that if you make eye contact, you're doing it on purpose, sort of to trick the officer that nothing bad is going on, and they think because of that eye contact, there is reasonable suspicion. So most Ninth Circuit cases agree that this is a situation of damned if you do and equally damned if you don't, meaning that it doesn't really matter both ways. Whether you look at the officer as you're driving by or whether you don't look at him, both answers would be wrong for the officer. For those reasons, the Ninth Circuit says that this is not an appropriate evaluation in this case. Now, if you're purposely concealing your face or you're making an obvious attempt to evade, the Ninth Circuit says that factor could have been appropriate. But again, in this case, the officer never testified that the reason why the passenger took the newspaper up was to conceal her face. Moving on to the next three factors, these are the ones that are appropriate. The first one is making a U-turn before the checkpoint. Again, there are cases out there that say making a U-turn right before the checkpoint on its own is not illegal and it shouldn't raise reasonable suspicion. But in this case, it does. We have two vehicles driving in tandem. So if making a U-turn on its own should not be suspicious, when two vehicles do it together, it kind of brings reasonable suspicion into play. It depends where you're making that U-turn. If it's a highway, like Highway 86, or if we're dealing on the road. The fact that the two vehicles made an immediate stop, well, that's important. That means that they made a U-turn right before the checkpoint, right next to the checkpoint sign. And another big factor is in this area, there are no turnoffs. So if there's another case where somebody's making a U-turn because they're confused or if they're lost, they've missed their turn, well, maybe in that situation, next to those checkpoints, there wouldn't be reasonable suspicion. But in this case, there is reasonable suspicion because there are no other U-turns or turnoffs off of Highway 86 in the area. So really, there is no reason for that individual to be making a U-turn. And again, a lot of times we're dealing with a situation whether that U-turn is legal or illegal. Obviously, making a U-turn on the highway is illegal. Most of the people take an exit when there is one and then make a U-turn. So again, in this situation, because we have these other factors around the checkpoint, the sign, the turnoff, the fact that the area itself is where a lot of people are doing illegal activities next to that turnoff, well, that's going to be drawing reasonable suspicion, which immediately brings us to the second factor. These individuals were driving in tandem and they both had Mexicali plates, so Mexican plates. Again, the plates themselves and when two cars drive together, that's not necessarily indicative of illegal activity. This factor alone would not be enough. But in this situation, these two vehicles are not just driving in tandem. They're doing everything in tandem. They're making the U-turn together, and then they're later stopping together on the side of the highway. Because of that, the Ninth Circuit says that is reasonable suspicion that something is not right here, and there's reasonable suspicion to investigate further. And finally, the third factor is the area. The officer testifies that the area is a well-known drop-off point by smugglers, either narcotics or illegal aliens. Again, the Ninth Circuit has to warn us that we're not dealing with a high crime area. This should not be a code word for race or ethnicity, that this particular neighborhood is a high crime area, so I'm going to stop everyone. That's not what's happening here. The Ninth Circuit says this area has nothing to do with race or ethnicity. We're talking about an isolated and unpopulated area. Most people are not stopping at that turnoff. There's nothing to see there, and there's no way that you're lost because there's no turnoffs off of that highway. For those reasons, the Ninth Circuit says that even if we take these two factors out, these three, the U-turn, tandem, and area being well known by smugglers and to law enforcement, these three are enough to bring reasonable suspicion into play, and that Border Patrol officers could in fact pull these two vehicles over. If this video helped you understand how reasonable suspicion works and how making U-turns in front of checkpoints works, I hope you click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.